Thank you all for coming to our third in the Domestic Violence Awareness Month series, where we are focusing on economic mobility for survivors. I am going to share my screen. And introduce myself. My name is Tunisia Owens. I am the Policy and Advocacy Manager at Family Violence Law Center for the Policy Department. And today's session is called Court Accessibility and Implications on Litigants' Economic Mobility. This October, which is Domestic Violence Awareness Month, Family Violence Law Center is hosting events throughout the month to highlight the experiences of survivors. Our theme this year is Methods for Impacting Survivors' Economic Mobility. We will view economic mobility through the lens of health, housing, education and training, legal and policy change, and reproductive justice. We believe that obtaining knowledge is one of the most important and powerful ways to protect the public. The agenda for today includes introductions of myself and our speakers, a panel discussion, questions and answers, and a closing from our esteemed panelists. Family Violence Law Center helps diverse communities in Alameda County heal from domestic violence and sexual assault, advocating for justice, healthy relationships in court every day. We provide survivor-centered legal and crisis intervention services and offer prevention education for youth. This webinar will focus on the intersection between court accessibility and the economic mobility of pro per litigants in the family court system. In this discussion, we hope to explore what legal assistance already exists and changes that can impact access to the courts for indigent people navigating the court system. I'd first like to introduce Judge Michael Bechet, who has served as a commissioner at the Alameda County Superior Court since 2018. He served as a commissioner and supervising judicial officer of family law at the San Bernardino County Superior Court from 2014 to 2018, and was a sole practitioner from 2001 to 2014. Judge Bechet earned his Juris Doctor degree from Loyola Law School and a Master of Education degree from California State University, Northridge. Thank you for joining us today, Judge Bechet.
Pleasure.
Erin Scott is our other panelist. She has been working on domestic violence and sexual assault issues since volunteering as a rape crisis counselor in 1990. She currently serves as the executive director at Family Violence Law Center in Oakland and sits on the board of directors of Uncommon Law. She is a former board member of the California Partnership to End Domestic Violence and Family Violence Appellate Project. She has provided legal services for pregnant and parenting teens and represented a survivor who was imprisoned for killing her batterer. Erin earned a BA from Swarthmore College and a JD from New York University School of Law. She is also currently enrolled in a master's in history program with the University of Edinburgh. Welcome. Thank you, Erin. And I'm going to stop sharing my screen. And I'd like to start by asking both of you a question. So can you please share a bit more about your work within legal or policy fields and how it ties to court access? And we'll start with Judge Bechet.
Sure. As a judge in Alameda County, we have several programs that are publicly and funded, and also through, for example, our partners like Alameda County Bar Association. Those are specific to self-represented litigants to assist them with various document preparation and other assistance, which we're going to get into. I'm also involved in training judicial officers who come new to us to family law. And we focus on how to handle and deal with self-represented litigants, their challenge. And of course, this is all well within the Elkins Task Force recommendation based on the Elkins case that came several years ago. We also have self-help and numerous other attorneys whose only job is to assist self-represented litigants.
Since it's in my bio, I do just want to reference, I did start my career as an attorney representing pregnant and parenting teens with a wide range of issues, but primarily Domestic Violence Protection Act and family law, and that was down in Santa Clara County. But that experience has very much shaped me as an attorney representing teenagers who had, both majority came from indigent families, but also were dealing with some of the barriers that come with being a youth, trying to access court. I bring that into Family Violence Law Center here. So we also provide access to justice for survivors through working on Domestic Violence Prevention Act orders, limited family law, and then in the last few years, housing cases as well, thanks to some funds from the state bar. We also do policy and systems change work, which Tunisia leads, and a lot of that has been at the intersections of domestic violence and housing and homelessness, and so really goes to the heart of both what it means for someone who's already struggling financially to deal with domestic violence and the really broad impact it can have on their lives, but also often experiencing domestic violence impacts people's financial health as well. So even if they didn't come into the situation, impoverished or close to it, they may end up there as a result of experiencing domestic violence. I do want to also add that the Domestic Violence Prevention Act has become an increasingly complex tool under California law. There's really quite a lot of different forms of relief that people can access. So I think sometimes people think of restraining order and they just think, oh, that's the one that, you're asking the person who's hurting you to stay away. But it's a whole lot more you can get with a DVPA order. And so when we're talking about access to justice, it really has become a pretty powerful tool for folks who are experiencing domestic violence to not only bring their own case, not the criminal case, but be able to come to the court and say, I need protection from violence. But it also can help them solve some of the issues that often for folks lead to increased violence, like issues like who has custody, visitation, who gets to live in the home if they're living together, property issues, even, the pet, if they have pets, that can actually be a point of contention that leads to more violence. And then, of course, financial issues like child support. So organizations like ours, there's Bay Area Legal Aid, who provides some limited family law and restraining order assistance as well in our county, but organizations like ours who help people get access to the courts, this is the kind of range of stuff that we're doing, even with just a protection order.
Okay. And I'm glad you brought that up, Erin. Are there other resources that are available to indigent litigants to ease that economic burden that can sometimes come with engaging with the judicial system?
Yeah, I guess I'll start and then Judge Bichet, you can jump in. But you already mentioned the self-help center, and that's a gigantic resource. That's so important because even, though there are some free, legal services in our county, it's not nearly enough to deal with the volume of folks who need assistance. And there are organizations like ours or Bay Area Legal Aid that represent the domestic violence survivor. We don't represent the other side, but either party can go to the self-help center and get some basic assistance with just, filling out paperwork, or even just like, I got these papers, what is this? Which is the experience a lot of people have. So I think the self-help center is priceless. So about those legal services, I will just emphasize over and over that there are not nearly enough of them to deal with the need, particularly the need when the case gets really contentious. That's when having an attorney in court is the most important. You can get good help filling out the paperwork and doing a good job and making sure you're checking the right boxes and asking for what you need. But when the case, when it really gets into litigation mode, having free attorneys available for folks makes a big difference. And I'll talk about that a little bit more later. But I do just also want to mention fee waivers, because I think particularly, with restraining orders, that's important, because restraining orders are free to file. There's just, you can file it without filling out a fee waiver. But then fee waivers are available, in family law proceedings, that someone can ask that certain filing fees are waived. And that's a pretty standard piece that's been in place for a long time that does make a difference for people being able to access the courts.
And Judge Bechet, would you like to add anything? And can you talk a little bit about the fee waiver process for litigants?
Sure. Well, I want to start definitely with the fee waiver, but I want to raise a point I think all of us know, and that is requesting a domestic violence restraining order is free. But for a case where it involves a dissolution of marriage or divorce or parentage, then filing fees do apply. The first step that a litigant should consider is filing a request for a fee waiver. It is a seamless process and it's confidential, and it can be quite beneficial with the savings, especially for people who would qualify those limited income. The next step, and I'm going to speak for Alameda County only, I don't know that neighboring counties do the same thing. What we realized is that for self-represented litigants, quite often they start the process and they make a mistake, for example, in serving the respondent. And then at the end, when they present a default judgment, we discover that service was defective and tell them to go and restart the process from the very beginning. And that, of course, would be undoing several months of hard work. And so what we did in working with Legal Access Alameda through Alameda County Bar Association, partly funded by them and the rest by the court, is we designed a self-help status conference clinic. So as soon as a self-represented litigant files a request for petition for divorce or parentage and files the proof of service, they get an automatic date in my department on Tuesday afternoons, where he or she will be met by at least 2 to 4 staff attorneys, several volunteer attorneys, and then justice fellows or volunteers who are here to help. They look at the petition, they look at the proof of service, and they help the litigant correct whatever is wrong or amend. And then they begin step 2, and that is disclosures for example, dissolution cases. And disclosures, they give them the form, they tell them how to do it correctly. And then they get sent to the home department, where they can file a request for order regarding custody and visitation and the like. And over there, there is a dedicated day per week in each department for self-represented litigants, where we have a second program that is called Day of Court. And those are also people, attorneys from Self-Help and Legal Access, who are going to be present. They're going to look through the pleadings. They're going to assist the party by running disomasters if child support is needed. They also prepare the findings and orders after hearing, free of charge to the litigant. And then finally, the final stage is judgment. When a judgment is presented, and at any time throughout that process, we have the gigantic help that Ms. Scott talked about, and that is self-help. And self-help currently in Alameda County, you can get assistance by text, by phone, by Zoom, or in person. And this has added quite a bit of flexibility to be able to render help to these people. And also, self-help can assist a party in with a long range of documents and pleadings. And if they're asked to assist in preparing a judgment, whether it's a default judgment or judgment that is stipulated between the parties, we have a mechanism where the self-help will send these judgments directly to me without them going through what I call the scenic route, the very long process, simply because self-help and I have been very involved and pouring into these people's lives. We know the need, we know the process. And so instead of sending it to people who may not be very familiar with self-represented people's needs, it comes directly to me and I review it, I sign it, and that bypasses quite a bit of possible challenges in the middle.
Thank you for that, Judge Bechet. Aaron, as an advocate, I'd like to hear about some of the barriers, the cost-related barriers and limitations that you can see arise for litigants who are trying to gain access to the court system.
Sure. So I'll just say a couple more remarks about needing more free legal services. There's an effort called, related to the Elkins Task Force, called Civil Gideon. Gideon is the name of the case that got us free representation for criminal defendants. So there has been some effort to pilot projects. They aren't widespread, unfortunately, but there are some pilot projects where parties are offered free legal services in civil cases. I believe there have been a few in San Francisco, but none in Alameda County, unfortunately. But in this area, part of the reason that I want to spend another minute talking about this is that we have seen over the past, I would say 5 to 6 years, more cases being litigated. I think some of this has to do with Family Code Section 3044, which does say that if there's a finding of domestic violence, that there's a presumption that the party who the finding is against does not have custody of the children, and the presumption can be overcome. But I do think that's led to more cases being litigated. And so, we see more and more people going into pretty highly contentious situations where, sometimes many of the relationships, the respondent has more access to funds, perhaps, they're a couple and part of the abuse was some financial control. So, sometimes they're able to hire an attorney themselves, but the petitioner is not. So, again, the need for attorneys to be able to actually step in and represent in court, we've seen an increase there. I also just want to mention, because I think it's important to understand this context, the history of legal services. In the late 19th century, one of the core beginnings of the legal services movement was women helping other women with exactly these kinds of issues. And as legal services became more professional in the early 20th century, the emphasis on family law decreased. There are family law services around California, but there's at least one large multi-county legal services organization in California that offers no family law assistance. So the legal aid movement is an anti-poverty movement that has disproportionately under-resourced addressing women's poverty in this crucial way. So I think it's important from a kind of policy systems change perspective to understand that. So when there are opportunities to advocate for that, we can do it. But so from that larger kind of systems point, I want to get down into some details in terms of what the litigants we see experience as cost-related barriers. So in addition to filing fees, which of course they can apply to waive, or if they're just doing a DVP action, there are no fees. Other fees can come up in the course of litigation. They may be ordered to go to parenting classes. Supervised visitation may be ordered. Therapy, which, may be extremely beneficial to the family, but still, comes with a cost. And although in some of our cases, the respondent is the one ordered to, when we're representing the petitioner, the respondent is the one ordered to pay for parenting classes or supervised visitation. There are still often registration fees, visitation center reports that are ordered by the court. And even though these costs, may seem de minimis, sometimes even an extra $25, $50 cost is cost prohibitive for our clients. And then there are just the costs of getting to court and the time spent in court. So transportation is a barrier for a lot of our clients now that, things are largely back in person. Missing work is an issue. And then childcare can also be an issue. And, there are cases where there are multiple continuances. I mean, sometimes because of some of the service issues Judge Bichet was talking about, but there can be other reasons for continuances. And so we're also not talking about litigants having to go once to court. It can be many times. So these are some of the barriers that are, financial barriers that we see litigants struggling with.
Thank you for that. Judge Bichet, one of the things that happened under COVID, it impacted the courts. And there might have been some innovations in how the court operates and also some challenges. Can you talk to us about some of the ways that court has changed in terms of accessing the court, and if some of those changes, what that impact may be on pro per litigants? For example, if you think about appearing, not having to appear in person, but video appearances, if that sometimes means more people can be scheduled because they don't have to appear in person.
Sure. My department is mainly a dedicated settlement department, other than the clinic that I mentioned. And so my department is the only department that is fully remote, and that I've seen a great benefit, not just to make it convenient for the parties, and even when attorneys are present on cases, but also the fact that instead of bringing people into our world that can be terrifying to some or making them nervous or stressed out, now we have litigants who are showing up from the comfort of their own living room or their kitchen. And that comfortable surrounding and environment has actually been extremely helpful in settling cases. The anxiety is reduced, so people are able to be more relaxed. They're able to think about resolving issues and resolving the differences in the case. The first thing that happened after COVID is the introduction of Zoom or other audio video platform. And thankfully, that has taken off in just about every court, as far as I know. And this is a huge cost saving. Why? Because before, the only way you can appear remotely is by using court call, and court call, I believe, was $110 per hearing. And that can really add up quickly. Second, it was audio only through a phone. Connection was terrible. The audio was terrible. It was a thing of the past. And thank God we are now moving into the new technology. The technology is very helpful in saving time, although some of the challenges is not everybody has a smartphone. So we are talking about a $1,200–1,500 investment right there versus $2.50 for a bus ticket. It becomes a challenge. Not everybody has a computer or a computer with a camera and a microphone. That is an investment. And the other challenges that we see is the court's ability to read and assess the demeanor and credibility. As you know, in family law, courts have to look and assess the truthfulness of the witness or of the party. Now, when we have everything remote, it becomes a bit easier. Everybody is on my screen. But when we have hybrid, where one person is here in person in the courtroom and someone is appearing from their office or from their home, becomes a hybrid system. The technology isn't quite there. I'll speak for Alameda County. They've invested so much time, effort, and money into a hybrid system. Every courtroom has these 85-inch TVs, telescopic zoom cameras, and the microphones. They actually wired and connected every courtroom microphone into the internet and the Zoom application, to where if you hear yourself in the courtroom from the speaker, that's what everybody else hears, versus having only one microphone in the middle of an entire courtroom and hope the person on the computer hears it. Now it is phenomenally advanced, but still not without glitchy connection from a person appearing remotely, or an inability or a bad internet connection and the like. The technology has a lot of way to go to improve, but we are grateful that it's here, and it's my hope that we continue to build on what forced us to go there, which was COVID. It's one of actually the positive things, very few positive things about COVID, is that it forced courts to find a different way and different mean. And when, courts are like cruise ships, they maneuver very slowly, and they don't make U-turns easily or quickly. And for us, this was gotta do it now. And we did. It's my hope that we don't revert back. Now, for Alameda County, trials are in person so that the court can assess the credibility, wants to see the entire person, not just the face. We want to make sure nobody's sitting to the right or left of the screen telling somebody what to say or do. And also becomes a lot easier in presenting exhibits when everybody's in the same room versus somebody is in a remote and someone is in the court, although that ability is now present. My personal concern about this technology is how everybody treats it. Meaning, I want to give you an example. I've had litigants and attorneys appearing while driving their car going to the grocery store or going to work. Others at the airport. I had one who appeared while flying from one place to another. I had an attorney who was sitting down in a busy restaurant having lunch and appearing on a case. I've had an attorney who was raising chicken in the backyard, couldn't hear a word because of screaming chicken. And he must have had like dozens and dozens of them. The worst example was a self-represented litigant who came to one of these clinics that are provided, and he showed up, he turned on the camera, he was wearing a bathrobe and clearly nothing underneath. And he decided to just lie in bed with the camera zooming in on his bed, putting his hands behind his head and smoking something that is rolled up, didn't look like cigarette, and a slurry voice saying, "Is this the court thing?" And the question that I pose with all these is, how serious are these people treating the court? And how much are we going to allow the convenience to dilute the integrity of and the respect that is due to the court? And finally, for example, that person who appeared in his bathrobe, what's the likelihood that he's actually going to hear my orders and comply with them if this is how little he has considered the court and how disrespectful he's become? How do I expect an attorney who's having lunch to take down my orders, prepare a FOA, and advise his or her client accordingly? This, to me, is the biggest challenge. Is we need to start speaking off the rooftop and everywhere we can. When you're in front of that camera talking to a judge, you are inside a courtroom. You sit properly, you dress properly, you speak properly, you listen accordingly. And I can't even begin to tell you how, when people are showing up from their home, I'm sitting in their living room rather than they're sitting in my courtroom. And then they want to talk to me how they would talk to their best friend or worst enemy. And the language that comes out and the style, the interruptions. And so to me, we need to protect this, and we need to protect it moving forward. And the way to protect it is by educating all involved. Respect this new tool. Do not abuse it, because I've seen counties who went back and said, "Why are we doing this? Take the bus. We'll see you in my department, where I'll have a sheriff who can put handcuffs on you, or I can find you in contempt if you keep disrupting me." And I'm hoping that we don't revert back to what is easier, and instead we educate the public and the bar on how to appear respectfully and benefit from this amazing technology that is the way of the future.
Thank you for that. Aaron, did you have something you'd like to add?
I was going to say, you really can't make this stuff up. It's just, you reminded me, we had a client who's, one of our attorneys was in court with a client, so in court, in person, who I guess the judge was off the bench for a minute, but they were still at counsel table, and our client decided to take a selfie at that time. So, it's just, yeah, it makes me feel very old. So yes, I think I agree. There are many issues, with the digital piece, and definitely with hybrid hearings. And I do want to underscore something you touched on, which was just the digital divide. Even if we have clients who have, a computer with a camera or a smartphone, often their access to the internet is really, really choppy. So, even if they're there with the best intentions and they think they've got all the equipment, they don't necessarily hear everything that's happening or can be heard. But that said, I will say that for domestic violence restraining order hearings, there is a lot of trauma from having to come to court and sit next to the person who harmed you, and the tensions in those cases are very high. And it is helpful, I think, for judges to see them in person, but it also is a very traumatic experience for a lot of survivors, for sure. And I think there may be some way of the future where, continuances, when we know it's a continuance or a status conference or things like that, perhaps can be on Zoom, so that not every appearance also incurs those costs that I talked about before for litigants. A couple other things. So we would love for the child care facilities at the court to be reopened. That has always been a game changer, because sometimes our clients are just in the place where their children are coming with them. And it's the time of the court hearing is very difficult for people who have to drop off children, if they're at a babysitter or even at preschool or a school. Sometimes those facilities allow you to drop your child off earlier, but that costs money, usually to arrange for that. So if you are a single parent and you've got two kids maybe to drop off at two different schools, and you have to be at court by 8:30 or 9, that's almost nearly impossible math to figure out how to do. So even if we could have some later court times, for cases that we know, or for calendars rather, that we know are going to have a lot of folks potentially in that situation, that would make a huge difference. And then I've talked about this a little bit before, but there are continuances or status conference review hearings, et cetera, that are necessary, but we are seeing some judges set quite a few of them, even in DVPA cases. And so again, for litigants who find it cost prohibitive to come to court, or have jobs that are really pressuring them not to do that, or jobs where they just don't get paid if they don't show up, these are having many extra hearings is an issue that we would like judges to think about when they're setting them, and be judicious about when they're doing it.
If I may just add one thought regarding domestic violence, those are governed by Family Code 6308, where starting January 1, 2023, and there was similar language starting January 1, 2022, but it got more defined, that a party, a support person, or witness may appear remotely at a hearing for petition of domestic violence restraining order. And being a new code, every county within that code, the code says that each county is supposed to develop local rules and instructions on how to make that a reality. And so definitely that code gives the option to domestic violence litigants and witnesses and support people to do this remotely, although I am sure many counties are trying to still put that into effect and in motion.
I had another question about barriers and folks accessing the court system. And this is for people whose first language may not be English. What are some of the innovations that the court has introduced to help with folks who where English is not their first language? And then, and that's, I'd like you, Judge Boucher, to answer that, and then Aaron, follow up with some of the additional barriers that might be presented when you're talking about non-English speaking or folks who also have are dealing with trauma or working through DV, sexual assault, those kinds of things.
I can say I'm going to agree with everything Ms. Scott says, even though I didn't hear it, just because this is such a difficult topic. Finding interpreters is a challenge. Of course, here in the Bay Area, I came from Southern California, and there were languages and also dialects that I've learned about since I came here, and finding interpreters for these dialects is so challenging. I remember requesting an interpreter and waited, didn't show up, continued the matter, waited, didn't show up. And so I called the supervisor and I said, what is going on? I went all the way to the top supervisor over language, and she informed me, we only have 4 in the entire state, and every courthouse and every county is fighting for them. To schedule them is such a challenge. So how do we fix this problem? Of course, we need to reach out. We need to put ads. We need to put in BART, bus station, and everywhere we can, saying, please come and do this service for us. Meanwhile, while we're working on this, I think for a litigant, especially whose first language is not something where we have many interpreters, such as Spanish, it's a different language. An example, Moroccan Arabic dialect, that's very challenging. Or Moroccan French dialect is challenging. Certain Urdu is not as easy to find interpreters for, and the like. I would say to these people, we encourage them, if you have a relative or a friend, someone you trust who speaks well English and your native language, bring them to court with you, because I can make a finding that a certified interpreter is not available. I can voir dire the interpreter and then qualify him or her to interpret, because no one else is available to do it. In this way, especially for something like a domestic violence restraining order, hearing or defending against it, or a trial for dissolution of marriage or parentage, we don't have to delay this, because the delay can be significant and can affect safety or well-being or best interest of parties and children. And so if I have someone in the room who can be sworn in and can testify that they're capable and of voir dire them, we actually have the language on how to kind of treat them as qualified to interpret, especially for the day.
Yeah, yes, ditto, I would say on that. I was, when I was preparing for this, I was trying to remember what year it was, but it may have been 10 years ago, where there was some effort, I believe at Laney College, to, set up a program to help people become certified interpreters. And I'm not sure what happens to that well, I can imagine probably funding, right? But yeah, I mean, particularly for languages, like you talked about some of the different dialects, that I know there are many languages where the dialects are substantially different. So you can't, get someone in another dialect to do the interpretation. But also we have, quite a few people from, in indigenous cultures in Guatemala, from Guatemala in particular, who speak languages like Mam, which actually comes with its own dialects. Yeah, we have a very, very diverse community here in terms of languages. So yeah, I mean, whatever that community college program was, you know, it would be great to have something like that, where people could go through a certification program. The other thing is the judicial council forms, which I know is not, you know, within the power necessarily of Alameda County judges, but to advocate for more, you know, for forms to be translated into more languages. Everything's in English and Spanish, which is great. And, you know, the Spanish language button is right at the top, right? So if you manage to get to the right page, like if you see that button, great, then you should be able to proceed from there. But I will say, you know, the DV100 is also in Korean and Simple Chinese. I had a hard time finding that page. I had to have someone here on my team link it for me to find it. So, you know, I think even though some of the forms are translated, like just how do people even get access to that? And of course, if they go somewhere like the self-help center, they can get that, but they have to get there first. And then, you know, in Alameda County, you know, the Korean language speakers are a very much smaller community than they are in some other parts of the state. So like Vietnamese and various dialects of Arabic are much more commonly spoken here, and we don't have court forms in those languages. But then I also just want to remind everybody that, you know, all of this is assuming a level of literacy that is not always present, even in English, for some of our litigants. So it's not just the languages other than English. It's also just remembering that, you know, to be able to work through the well-written and fairly simple instructions, you know, that are available on the Judicial Council website is still a challenge for some of our litigants. So just a couple of finer points that I think you know, maybe some things for the county to consider. So, you know, court orders and court minutes, they're read to the parties, but there won't be a written version in their language. You know, they're read to the party with an interpreter, you know, in court, but they won't walk away, you know, with a written version. And given how traumatic, you know, lots of family law proceedings are, but particularly the domestic violence proceedings, you know, what people retain in the moment in the stressful, you know, atmosphere of court is not always accurate. And so having that written document in a language you understand is pretty important. Because as I was saying, we are seeing more and more cases litigated, you know, the issue of presenting evidence has become more of a concern for non-English speakers. You know, what they're supposed to do is get it translated into English in advance, you know, before presenting it to the court. That costs money. You know, a lot of people don't even know where they would begin, you know, without assistance. So if there was more of an option to bring, you know, the language, the evidence that's in another language to court, have it interpreted live by, you know, have it translated live by the interpreter so that it can be read into court that way, just would provide some more access for people when they want to present evidence. And then just, you know, I know the court, Alameda Court is always looking at different ways to connect litigants with other resources. So, you know, and some of them make it to the self-help center, some of them don't, but to have, you know, resource lists in court for non-English language speakers, perhaps even so, you know, they know where to go if they're holding a court order in English, and again, maybe heard it, but are not retaining all of it, like what is available out in the county to help them. And even though that resource list is not going to be as satisfying as we would like it to be, you know, at least trying to direct them somewhere if they need some support after they're in court.
Do either of you have opinions about technology tools and using them in this arena in terms of translation? Because, you know, there are terms of art in the law, there are legal terminologies that make it really important to get that translation right, get that interpretation right. So Google Translate may or may not be as effective for a party to understand the legal significance of the court orders. Are there other tools that exist, technology tools that might be helpful if imperfect?
Not sure about the forms and translating the forms, but one of the new tech that I really like is a bridge line. Having a bridge line, meaning that especially in a remote setting where the interpreter connects with the litigant who needs interpretation directly. And if it's in the courtroom, they bring headphones and the interpreter speaks into a microphone, and that cuts the hearing in half, or takes it from double time to real time. Because when you have someone who is speaking, and then you need time for the person to interpret, and then the conversation becomes so fragmented, it takes away from a lot of what we need to determine, whether it's credibility or hearing the full story, getting feedback from the person who's telling the story when that person has to say it one sentence at a time and then a long pause and so on. It does affect the overall time, but also the presentation of that witness. But when we have bridge line, there is simultaneous interpretation that is taking place. And frankly, it improves everything. And so I'm very grateful for that little piece of technology that saves so much time. And it really lowers the temperature. As people pause to allow the interpreter, that is time for people's temperature to go up versus it's happening all in real time, like a conversation like we're having here, without the person who needs the assistant losing anything in the process.
Yeah, that's great. And I think that, I've been to many conferences, with simultaneous interpretation for folks. So it's been a technology that's there. I'm glad to hear that's being used more in the courts. For, the document translation, I just don't think we have a really good option. I'll give you an example. So, one of our community partners, Blue Harris Unitas, the majority of their staff are monolingual Spanish speaking, or the majority that I interact with. And so they tolerate me using Google Translate. I basically asked if it was okay, it's imperfect. But that's a professional speaking to a professional, right? So they also are going to clarify with me, and, we're peers talking to each other. So it's a very different situation. And it makes my attorney heart very nervous to think about using Google Translate for court forms or court orders. But I mean, I know almost nothing about AI, but who knows, what else might be possible. What I will also say, though, is that I understand, I think I like the cruise ship analogy that, the justice system is a very slow moving entity. But even if we just focused on like the Domestic Violence Prevention Act forms and got those, at least getting the forms and the instructions translated into more languages, that would be, it shouldn't be that hard. We have a translation company that we use to when stuff comes through our office or to translate our instructions, and it's that those kind of like maybe 8-page documents, that's very de minimis cost to get it translated. So I don't think that's something we should stop advocating for. And then maybe there should be at some day, it seems like this is possible, some way for there to be simultaneous translation through your computer as you're putting the order in, that it can spit out, with a little programming to account for some of the nuances of the legal terms, that we should be able to spit something out that we can hand to people. That doesn't seem, if we can do all this hybrid stuff that we never thought was possible, you know, until, like you said, the pandemic sort of pushed us to make it happen. I'm hopeful, you know, that these things ultimately, with, I hope, very little cost to the court, because I know that's always a huge consideration.
And one of my last questions is about recent changes within the Superior Court that could make accessing the courts better for pro per litigants who have disabilities. So are there recent changes, or and then for Aaron, are there barriers that oftentimes you don't necessarily think of, but that people with disabilities, and this includes physical disabilities, intellectual disabilities, and invisible disabilities. So we know that the pandemic has definitely highlighted mental health issues, and how, and I know Judge Bechet, you mentioned anxiety, and, you know, folks being anxious in court, but there are a multitude of disabilities that might be highlighted in trying to access the court. And what are some ways that the court is working on making things more accessible for folks with disabilities?
Well, I think going back to the hybrid or remote availability, I think this is huge for people who are not just on disability, but also people who are high risk, who don't want to be exposed to the flu or COVID or the like. This has been a phenomenal tool. If you go back and read one of the earlier cases on how someone was disabled, I believe it was in a Long Beach court or something, where someone he was not able to use his legs and had to go up the stairs, 10 flights of stairs on his hands, because that's what it was, and then was a bit late and it didn't go well, and see where we are now. And I think there's a lot for us to celebrate of how far we've come, but not say the end. This isn't the finish line. This is, we've made multiple milestones and there is more to be done. Now, balancing that with convenience, for example, one of the things that I really love and appreciate right here at Hayward Hall of Justice, which is the courthouse for family law in Alameda County, is that in the parking lot, there is a shuttle bus that's going to take you to BART, that's going to take you to where you need to be, even if there is no direct transportation to the courthouse. I think these things, you look at them and you say, somebody said, we're not holding up, it is finished. We're holding up a sign saying keep going. And we love and celebrate the ability for people to use that free transportation to get to our court from BART and so on. Balancing that with educating litigants of where it can be too far. Showing up with your 7 dogs and saying there are all for comfort. I don't want to judge this, but can you see how that becomes extremely challenging? How do we get 7 dogs in the courtroom? How do we contain them? How do we deal with it? I have heard of someone showing up with a cobra snake, and it's for comforting. And I heard, I don't know, but I heard that they also had a letter from a doctor saying that that calms that person down. How do I put that person at counsel table where the snake is within bite space from the opposing party? And do I grant that request and expose Madam Court Reporter to a venomous bite? How far do I go in making this a possibility? And yes, the science is expanding. I just don't know, back to the cruise ship, that we can speed up and begin not just to make quick U-turns, but in my opinion, in the Cobra example, that's asking a cruise ship to take up wings and start flying to the moon in an instant. And I just don't see us at the level at Beam Me Up, Scotty, yet. But hopefully we get there. I just need also doctors, attorneys, people, members of the public. When you write a letter like this, keep in mind who else is in the room, right? Who else is on the airplane, and so on. I got on a cruise ship one time, and I saw one person who had a pet for emotional support. That pet was over 200-pound dog that was a very vicious breed, that they had to actually put that person in a cabin with a huge balcony to make the dog comfortable and able to get up and sit down, because it was a monster. And when that dog came to the dining room that's packed full of people, you would see sighs, screams, people tripping, falling. And we're talking about elderly folks who were tripping, falling, removed from the ship because they broke this, that, the other thing. Where is that balance? I don't know. We need to listen to science. We need to provide the comfort, but we also need to recognize that there are other people who are in the same room, and we need to be mindful of that as well.
That's fine. I was going to bring up support animals if you hadn't, but yes, I do think that, yeah, I think there need to be some, I think science hasn't quite found its footing there either. I think we need to be some clarity around when an animal is truly a support animal, like medically necessary or whatever our designation is going to be, and when it isn't. There are people that are very afraid of animals, and like you said, so it's just there's a balancing act, and I'm not sure that we have the final word yet from where we need it from in order to be able to assess. I actually, along these lines, am going to raise something that is sort of an old, long-standing issue, but I think it's so important that it needs to be highlighted, in part because, family court and the restraining order calendars in particular are places where a lot of brand new judges get placed. And, we know they get education and support, but, they're new still at the end of the day. And, you can give people the best education in the world, and still it's, I'm sure, incredibly overwhelming, to be sitting on the bench for the first time. So I think we are gaining more and more understanding from science every day about the impact of trauma on the body, the impact of trauma on the mind, the impact of trauma on, unborn fetuses, like fetuses in the womb are impacted by trauma. So we're learning more and more about that every day. But I think one of the fundamental impacts of trauma that clashes directly with the way the judicial system is set up is trauma's impact on the ability to tell a linear, consistent story. And one of the one of the things that we do a lot with the litigants who come to us is helping them piece their story back together in a way that is going to make sense for a court pleading, for a petition. Because, they are often still very much in their trauma. The memory can be very inconsistent. And the ability to tell the story from A to Z, it's not going to go that way most of the time. So that's a lot of what we're doing, as their representatives, but there's so many unrepresented people, right? So, and I've seen judges who are very good at this, it's sort of working with the person where they're at and kind of eliciting what they need, for the judicial process, in a way that, like they're listening deeply. So they're listening for what they can put together as a linear story. And, whether that's instinct or, personality, or whether they actually really understand the impact that the trauma has had on the litigants. But not everyone's going to come to the courtroom with that kind of natural instinct. And so I think we need continual education, especially as the science develops, on what this really means and how someone is presenting themselves. And I think one of the hardest things in a judicial setting is that one of the symptoms of trauma can be defiant behavior, or the really inability to control some of your emotional reactions when you're still really deep in experiencing trauma. And that's hard, I mean, when someone raises their voice as a judge, like, how do you handle that? And I'm not suggesting that everyone should be allowed to yell. I mean, that's not going to be productive, but there are ways to handle it, to de-escalate what's happening, that, there are de-escalation techniques that are effective, and there are approaches that are not effective. So, this is not necessarily what everyone who becomes a judge thinks they're walking into, these kinds of sort of psychosocial, like, understandings and skills. But I would argue that even beyond family law, these things are helpful, that, you have humans before you appearing in court in not their best moment, regardless of the type of case. So I just really do think that the court investing more in ongoing support and training around these issues, and helping judges learn techniques to be able to do what they need to get done as a judicial officer, and, and get the best out of the litigants, particularly when they're pro per.
I want to echo that, and this is a big deal for me because I've been in family law 22 years, and so and what got me into family, I went to law school to do family law. If I had heard that there's no law, family law at the end of law school, I wouldn't have gone to law school. I wasn't interested in being a lawyer. I was interested in going into family law and making a difference. And to me, the reason, the motivating factor, and what we teach new judges who come to family law as a new assignment, we say two things. One is family law is very similar to the emergency room, and you're like an emergency room doctor. It is ridiculous to tell somebody, I understand there is a pole sticking out of your stomach, but I need you to be calm. I need you to be polite. I need you to be the perfect human being. These people are hurting, and add to it the anxiety and the fear. They don't know if they're going to go finish this here and go back to their home, or they're going to be kicked out of their home. They're going to go away with their children or not. They suddenly, their entire life, which they believed in the forever, right? Till death do us part. Suddenly, that future, my future and my children's future, is in a judge's hand. Someone I don't know, in a place I don't know. It looks sanitized and it's not very warm. The walls are white, and a person who walks in, even from state your name, and you see someone who said, what did you say? Don't get frustrated and To me, what helped me a great deal is every day when I see someone get antsy or anxious or frustrated, I put myself in their shoes and I recognize if I'm going through that divorce and I may be losing my children, I will have the same anxieties and then some. And so it becomes my job, my duty as a judicial officer, not only to acknowledge the anxiety and the fear, because it's normal, it's natural, it's warranted, but it is my job to calm that fear. It is my job to say, I am here to listen. I'll give you every opportunity. You will tell me what you need to tell me, and I'll make a decision based on the best interests of the children. I have them in mind. I am here to do what is best for them, and your input is very valuable to me. These things, it's a huge bucket of ice on a raging fire, and it is so important to do. Yet at the same time, as Ms. Scott shared, it is critical that we also protect the process and the courtroom and the cooperating party from someone who wants to come in and bully the other party inside a courtroom. So for that, I need to use very clear facial expressions, hand, and very, very stern tone. No, you are not going to yell in my courtroom. I will hear from you, but please take a moment, take a deep breath, calm down. I can't hear you when you're yelling. So let's all of us take a minute break and we'll start over. There are times when I had to say stop in a very loud voice to someone, a litigant who isn't listening, to saying, okay, just a moment, and starts to increase the volume. And it's one of the judicial canon. It is up to me to manage the courtroom. And I need to protect the decorum of that courtroom for the sake of the litigant, who's probably terrified that the other one is flying off the handle and is screaming really loud. So the balance, as Ms. Scott said, and also the training, we need to recognize why these people are before us. And finally, there are not files, there are not cases. There are human beings who are going through the worst chapter of their lives. We need to call them by their names. We need to explain that this is about them and their family, not about my file and my caseload. And once we get that, we're going to have a great relationship with these litigants and nudge them along and guide them along to the finish line in their past so that they can start the future and the first step and the first day of the rest of their lives in a new chapter.
And I'm sorry, can I add one other thing that I was remiss in not saying? And there has been more research about this lately and trainings, I think, largely for criminal law practitioners. But one other thing I would say to the bench is if you see allegations of strangulation or choking, the majority of people who experience that are not checked for brain damage, but brain damage is very common and impacts all the things we're talking about, in someone's behavior. So I just want to, point that out, that there is, a disability can be created from that kind of violence, and it's unfortunately very common. And so if you're seeing that in pleadings, it's a very good indicator that someone is going to have difficulty telling you their story in linearly, calmly, etc. So just want to raise that just particular point, since there is some really good research now, and since it is something that most people don't get medical care for.
Thank you both for that information. I'm going to share my screen again and ask you both for your final thoughts. So if you can, we'll start with Judge Bechet, 30 seconds. I know we're over a little bit over time, but 30 seconds. Tell us your final thoughts, and Aaron, 30 seconds, and give us your final thoughts as well.
I am grateful for the opportunity to be here and share our thoughts or my thoughts about this process. And we have to recognize that the very vast majority of litigants in family law are self-represented. And so we can't focus on the attorneys in their, I don't know, 20% of the cases and forget that 80% is self-represented litigants. We need to continue to think of ways and find ways to pave that road and make it easier for self-represented litigants to appear, to present their case, and to be able to reach timely finality to their issues and their concerns and their case and their process. To that end, I am absolutely delighted and proud to be part of the team we have here in Alameda County. The extra programs that they offer. And I can just wrap it all in one example. When a self-represented litigant was in my clinic and an attorney from Self-Help and Legal Access was preparing documents, and I noticed that it was voluminous and the extent of it. And I asked and I said, well, is there a way we can make this faster and easier for you? And her response was, I am here. That's my job. This is a worthy litigant like all of them. And if I'm going to do it, I need to do it right. No need to worry about speeding. No need to worry about anything. I am doing my job and happy to do it. That attitude is where we need to all be and join our efforts to keep on going to the next step, and then another, and making it easier and possible for all litigants to appear here and receive equal justice and timely and expedited process of their needs and their cases and their requests.
So beautifully said. Thank you so much. And I would just offer, this is being recorded. We're going to distribute it widely, and I would request, if you're comfortable, Judge Bechet, to share this, throughout with the bench. For anyone who's interested, we will share it out with our networks of attorneys as well, because I think one of the things you've been highlighting is also the role of pro bono attorneys, and what a difference that makes, since we do not have enough free legal assistance. And for the attorneys who are watching this, I do want to add just one new element, which is encouraging people to sit on the Judicial Appointments Committee of the county bar. So there's a statewide Judicial Appointments Committee, and some counties have their own, and Alameda County is one of them. I've sat on the committee and found it to be very rewarding, because your role is reviewing applications and then interviewing possible future judges. And all the issues that were brought up today are things that I think are really important for people who want to be on the bench to think about, because as you said, Judge Bechet, these are not files and cases, they're humans. And not just in family court, but in places like family court, you're much more present to their humanity. And so I think, being in places like judicial appointments committees where you can raise these issues, and ask that judicial candidates really think seriously about these things, and if they need support, or training, that they get access to it just as they would, in a new area of law that they're not familiar with.
Well, thank you both. I'd like to thank Erin Scott, Executive Director of Family Violence Law Center, and Judge Michael Bechet for speaking to us today about accessing the court for pro per litigants. And then I'd like everyone attending to keep an eye out for the rest of our Domestic Violence Awareness Month activities. There will be a day of remembrance held at the Family Justice Center in Oakland on October 27th from 10:30 a.m. to 12:30 p.m. We also, Family Violence Law Center, will be hosting a movie screening called Surviving International Boulevard, also on October 27th from 2 to 4 p.m. at Oakland Main Library. There will be popcorn and movie snacks and a community discussion following the movie screening. And then we also will be hosting another webinar on economic mobility and reproductive health on November 1st from noon to 1:15 p.m. on Zoom. Thank you all for attending.
Yeah, Tunisia, can I just add one late breaking thing that I just confirmed that we can send out information about, but I also sit on the Alameda County Commission on the Status of Women, and Family Violence Law Center is going to be co-hosting with the commission a webinar on the U.S. versus Rahimi case, which is currently before the Supreme Court, that is going to decide the issue of whether it violates the Second Amendment to prohibit people with a restraining order against them from having guns. The oral argument is on November 7th, and that webinar is going to be on November 16th. We'll post information about that on our Instagram and other platforms. We're going to have Corey Hernandez from the Family Violence Appellate Project, and Julia Weber, who has been with the Giffords Law Center and others, and is an expert on the intersections of domestic violence and gun violence. So very excited to just confirm that.
Thank you, Erin. And we are very excited as the policy department to participate in that conversation and to continue with Domestic Violence Awareness Month all the way into November, having these conversations, educating the public, and talking about these important issues. So we appreciate everyone who attended, and we appreciate you, Judge Bechet, and you, Erin, for joining us and educating us a little bit more. So thank you, and have a good rest of your day.
Thank you. Are we done recording? I do have something I want to share after the program.